If it pleases the court, Your Honour, my name is Taylor, Taylor, initial T, and I appear for the defendant XYZ Proprietary Limited and am instructed by Jones & Jones Solicitors. Your Honour, today I will be presenting you with two submissions. My client will be abandoning the submission regarding ABC knowing of proposed changes handed down on the budget on the 7th of September 2019. If it pleases the court, Your Honour, the first submission will be in regard to the negligent misrepresentation of business earnings. Negligent misrepresentation occurs in circumstances where the person making the representation was under a duty to disclose, duty to ensure that they were telling the truth to the other party but failed to meet that duty. Your Honour, it is submitted that ABC was under a duty to tell the truth, that ABC made a statement that fell short of this duty, and that my client suffered harm which was attributable to this misrepresentation. ABC was under a duty to tell the truth to my client. My client claims that ABC grossly misrepresented the takings of the business and therefore the true potential of the company. My client states that before signing the contract, a representative of ABC stated that the average monthly takings of the business was $73,000. However, since my client started operating the business, the average monthly takings have been $53,000. This was a false statement of a material fact made by ABC to my client in order to induce my client into entering a contract. The misrepresentation is attributable to the harm my client is now suffering in the reduction of monthly takings and subsequent reduction of the business worth, which after the engagement of a forensic accountant is now believed to be $730,000. The facts of this case bear similar to the recent case of Shah versus Harriman, 2018 FCA 91. This case concerns the sales of a Subway franchise where the defendant misrepresented the sales when selling their business in order to achieve a higher sales price. The plaintiff, after purchasing the business, subsequently discovered that the business averaged less than $12,000 weekly, which was subsequently substantially below the average represented sales figures of over $16,000 weekly. After considering the arguments of the defendant, the court found that the seller sold the business during a period of cash flow problems and poorly trading performance, and that in order to inflate the sales price of the business, he had created fake sales. That the buyer would never have agreed to purchase the business if he knew the sales were fake, and it was not unreasonable for the buyer to rely on the reports as provided by the seller, as these reports were generated by the store and were regarded by both franchisees and prospective purchasers as important and reliable records of the store's sales performance. The court ordered that the seller pay the buyer $300,000, being the difference between the price paid by the buyer and the true value of the business. It's noteworthy in this case that the court determined that the business takings were relied upon by the purchaser. Had the representation not been made, the purchaser would not have agreed to the contract. Despite the naivety and overly trusting purchaser, the court found that it was the misrepresentation that was the direct cause of the loss suffered by the purchaser. Your Honour, although my client may have also been naive in trusting the documents provided by ABC regarding the business takings, it is clear that my client did rely on these provided figures for the purchase of the pharmacy. If Your Honour agrees with the negligent misrepresentation, my client will be seeking damages today. If Your Honour is not satisfied with the above claim of negligent misrepresentation, if it pleases Your Honour, we would introduce an alternative equitable claim of misleading or deceptive conduct under Section 18 of the Australian Consumer Law. In order to show misleading or deceptive conduct under Section 18 of the Australian Consumer Law, a corporation must not, in trade or commerce, engage in conduct that is misleading or deceptive or likely to mislead or deceive. The first element is undeniable. ABC Proprietary Limited is a company incorporated in Australia and therefore satisfies element 1 of being a corporation. The second element, in trade or commerce, again, this element is one that should not be denied. ABC Proprietary Limited engaged in business ventures in the owning of and subsequent sales of the pharmacy. The third element, engage in conduct. Conduct is defined in Section 2, subsection 2b of the Australian Consumer Law as a reference to the doing of or the refusing to do any act. When a representative of ABC provided financial documents to my client, they engaged in conduct. Whether or not this conduct is misleading turns to whether it tends to lead into error, as per Campbell and Back Office Investments Proprietary Limited, 2009, High Court of Australia 25. My client was led to error when the inflated business takings were provided by ABC and is now subsequently suffering due to this error. If it pleases the Court, Your Honour, my second submission will be in regard to misleading representations with respect to future matters. Under Section 4.1 of the Australian Consumer Law, the ACL, the representation is taken to be misleading if the person making the representation with respect to future matters and a person does not have reasonable grounds for making the representation. ABC misled my client when they made the statement, "This business has been very stable in the same location for the past 8 years and we expect nothing will change in the future." However, ABC does concede that it received information prior to settlement that the medical professionals adjoining the pharmacy were planning on relocating. This information would be detrimental to future business takings. However, ABC did not disclose this information to my client. As to whether silence may be misleading or deceptive under Section 4.1 of the Australian Consumer Law, conduct is defined in Section 2, subsection 2b of the Australian Consumer Law as a reference to the doing or the reference to do any act. In turn, refusing to do any act is defined in Section 2, subsection 2ci of the Australian Consumer Law as a reference to refraining other than inadvertently from doing that act. As per the case of Miller and Associates Insurance Brokers Proprietary Limited and B&W Australia Finance Corporation 241 CLR 357, when silence is alleged to be misleading or deceptive, it will be so where there is a reasonable expectation that the matter kept silent will be disclosed. It would be reasonable in this instance for ABC to disclose such critical information. At common law, silence can give rise to an actionable misrepresentation when there is a duty upon the representor to reveal a matter if it exists, and where the other party is therefore entitled to infer that the matter does not exist from the silence of the representer, as per W. Scott Fell & Company Limited and Lloyd 1906-4 CLR 572. If I could ask Your Honour to refer to the case of Hanyo Investments Proprietary Limited and Colin Macraville Proprietary Limited, 1988 37 FCR 546. In this case, the vendor sold a business knowing that it was subject to serious limitations upon its lawful seating capacity, which vitally affected the business takings and profitability. The vendor's agent had given the purchaser to understanding that the limitations upon the seating capacity and the limitations arising from the licensing of the restaurant were less restrictive than in fact they were. These circumstances give rise to a duty on the party of Hanjo as its vendor to reveal the true position to Collins and potential purchaser before any contract was signed. Your Honour, in the case before you today, it is clear that information regarding the relocation of the medical professionals that are joining the pharmacy would be critical information which would vitally affect the future business takings and profitability. And although my client acknowledges that ABC may not have been aware of the information at the commencement of negotiations, they did become aware of the facts before settlement. My client relied on the information provided by ABC and had all correct representation been made without silence, my client would not have agreed to purchase the pharmacy, or would have done so for a considerably lower amount. Your Honour, if you are in agreement with the misrepresentation by ABC was the direct cause for the loss suffered by my client today, then we will be seeking damages. Thank you, Your Honour.